Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, Jackie. Welcome to the Fourth Circuit, even though it's by video. And we're ready to hear our first case, 19-2094, Purdue versus Sanofi Aventis. Ms. Gessner, we'll hear from you first.
Yes, Your Honor. Good afternoon. May it please the court. I'm Michelle Gessner, and I have the privilege of representing Janet Purdue today in the case that's before you. Thank you for the opportunity to be heard. We're here today, as you know, appealing the district court's ruling of summary judgment in favor of Sanofi and on Ms. Purdue's Americans with Disability Act claim, as well as her wrongful termination claim. The district court's errors in this case are reminiscent and similar of the same errors that were made in a case before this court in 2015, that being the Jacobs versus NCAOC case. In that case, the Fourth Circuit recognized that where a motion that is designed simply for identifying trial-worthy issues was improperly used as a vehicle for resolving trial-worthy issues. The same is the situation before you. The district court in this case construed all the facts in the light most favorable to Sanofi, the moving party, as opposed to looking at the facts in the light most favorable to Ms. Purdue. And in fact, the court went so far as to insert what would happen with those facts and what a jury may find in those facts and forecasting the future. And Ms. Purdue and the appellant before you contends that that was clear error. Ms. Purdue had sought a reasonable accommodation from Sanofi as part of her job. She had worked for Sanofi Pharmaceuticals for 16 years. She was a sales rep. She had, at the age of 44, had found herself in the unfortunate position of being diagnosed with an autoimmune disease. And while working for Sanofi back in 2013, she was able to take a leave of absence and miraculously work her way back to full-time employment. In fact, critical in working her way back to full-time employment.
Counsel, we're fairly familiar with the facts, and I know since you have limited time, it's up to you on how you want to present, but you may want to move directly to your legal arguments.
Yes, Your Honor, we'll do that. In this case, Ms. Purdue's reasonable accommodation should have been granted, absent an undue hardship. There was ample facts to show that the request to job share with another employee pursuant to Sanofi's Flex Works program was reasonable on its face, primarily because Ms. Purdue had job shared before, and the Flex Works program specifically allowed for job share as a way to accommodate employees to remain employed.
Now, counsel, can you sort of help me here? I assume you agree that if your client had asked Sanofi, requested that they create a new position in Greenville, that wouldn't be required as a reasonable accommodation. You agree with that?
Your Honor, under the law, an employer must not create a brand new position, but that is not this case.
And so that's where I want to go. So here, as you just described it, you requested a new job share position. And so help me understand why I shouldn't think of that as the same thing as creating a new position altogether. There was no such position before, and maybe they were certainly permitted under the policy to create that, but it seems to me that there had to be an existing position that before we even get to your argument. So help me understand why this is different.
Yes, Your Honor. There was a position in the Greenville market for a sales rep. That was the position held by Caitlin Hunt. The company's own program allowed for that position to be shared under the FlexWorks program. The first step was to check in with HR and confirm that that position was eligible to be shared before even the request could be made. And that box was checked here. Ms. Perdue and Ms. Hunt contacted Sanofi's HR and was told that Mrs. Hunt's position was eligible for sharing. The second piece, which was part of the first, was Ms. Perdue was required to find her own partner. This isn't an instance where Ms. Perdue went to Sanofi and said, create a position for me, find me a partner. Instead, if she had not found another sales rep, Ms. Hunt, who was willing to cut her pay in half, cut her bonus in half, and share the responsibilities, ebbing and flowing as one in the same position, Mrs. Perdue would not have had someone to go to Sanofi and make this request.
So help me a little bit, because so you're reaching the different conclusion, but the words you use, it's eligible to be a job share. It could be turned into a job share. All of those suggest something that had not happened at the time that you're making the request, that those were things that could have been done, but it was not a position, there was not a job share position at the time. And that's the rub that I'm having. I understand your position to be that this could have been done, that Sanofi had every ability to do this, but I don't think that gets you anywhere, right? The fact that they could create a new position for her, right? They could have promoted her to CEO. I mean, they could have done all sorts of things. But the question is, was there a vacant position, like one that existed? And if not, you're at a full stop before we get into Ms. Hunt or any of these other facts.
Your Honor, if I may, let me step back just for 1 second. Our position is that the job share didn't even require there to be an open position in order for the company to consider the job share for Ms. Perdue. She wasn't seeking a new job. She simply was seeking to do her current job, a sales rep, in a different territory. This wasn't create a new job for me and plug me in it because I'm disabled. Instead, this was allow me to do my current job, a sales rep, in a different territory. And so
but you agree, but I thought we started this conversation by you agreeing that if she asked for them to create a job in Greenville as a sales rep that was not existing, that they're not required to do that. I mean, they're entitled to do that, right? They're perfectly capable of doing that. And if they chose out of the goodness of their heart to do it, that's great. But they're not required to create a position for her as a sales rep in a different geographic area. That's the same problem that you've got. That's what I'm just having trouble understanding the argument.
Your Honor, the job share program was akin to a job restructuring, and the request to job share with Mrs. Hunt was part of the program that Sanofi itself allowed. The analysis of whether Ms. Perdue should have been given the job share should have been looked at in the context of the ADA. The ADA requires the disabled employee to have an equal opportunity. In this specific instance, Mrs. Perdue was looking for every opportunity to remain employed with Sanofi. There were very few options. One of the options was to work the program that they have, the FlexWorks, and to see what would work. Part-time work in Asheville would not work. The only thing that was available to her was job share. And in that context, Sanofi needed to consider job share and only deny if it could show an undue hardship. And here, Sanofi did not do that. The position with Mrs. Hunt was an existing position that a willing employee was willing to give up half of to ebb and flow with Ms. Perdue to make one. And if that was created a hardship for Sanofi, it had a legal argument. It didn't make that argument at any point in time in the lower court or even before this court. And if it can, Your Honor, it can do that in front of the jury. But this was an issue that was decided as a matter of law by the judge in this case, by the district court, which was improper. Mrs. Perdue made an argument and made a showing that her request was reasonable on its face, both in a job restructuring, which is absolutely one of the reasonable accommodations cited by Congress, and it is not exclusive, just as cited by this court in Elledge. Job share could be one of the listed factors in reasonable accommodations. And here the court denied it as a matter of law, despite there being ample evidence that it was reasonable on its face, as well as it did not evade the rights of any other employee. Your Honor, your question is astute in the sense that there was not a single person who was vying for a job share. Job share was not something the company posted. This wasn't an open job that would be eligible or be available to others. This was an opening was only created when a need occurred and the employee needing the same could find their own willing partner. That's the only time that this would be available, is if those elements were met. HR approved it and the person found a willing partner. And in this case, I'm out of time.
Thank you.
Well, you can finish your answer.
Yes, Your Honor. In this case, there was no other option available for Ms. Perdue. And importantly, the company did not engage in the interactive process in any way to find other options. So Ms. Perdue did, all the way to the very bitter end, look for other solutions once job share was denied. However, Sanofi did nothing, and there were no other solutions. Instead, Sanofi post hoc blamed Mrs. Hunt as the reason why it did not accommodate Mrs. Perdue. And there are so many factual issues around that analysis, Your Honor. Our submission is this case should have been rendered to the jury.
All right. Thank you, Ms. Gessner. You've got some time left on rebuttal. Ms. Gantz, we'll hear from you.
Thank you, Mayor. Please the court. I just wanted to address the judge's issue about it being a reassignment to a job that didn't exist. So the ADA has a number of options for reasonable accommodation listed in the statute, and what you call it doesn't really matter. So a job share could be a part-time or modified work schedule. It could be job restructuring. It could be seen as an appropriate modification of the company's policy, but the company here had a specific policy that allowed job share. So the key here is that reasonableness and whether an accommodation is reasonable is a general showing. Is the method requested ordinarily in the run of cases feasible? Is it plausible? Is it effective in that will it let the plaintiff or the worker perform the essential functions of the job? Then if there are business related concerns, the burden specific concerns having to do with how the business operates, then that would shift to the defendant to show on undue hardship. And the problem here is that the court never shifted.
Was there a vacancy here?
Job share by definition is the splitting of one current job. So the idea of a vacancy doesn't really work here. A vacancy usually is a job that others can compete for, or that there might be other employees wanting the job, which is the problem when you run into a seniority system or the kind of best qualified policy at issue in Elledge. Here, the job share would not have affected any other employees at Sanofi, and it all was determined by her finding someone willing to take a 50% pay cut and share the job.
So there's no vacancy here.
Excuse me?
That's your answer. There's no vacancy?
No, there was if you want to put it in those terms, the vacancy occurred when Caitlin Hunt agreed to share her job share. So at that point, they submitted a proposal which the company considered. The company had to, if they didn't want to do the job share, that was certainly in their prerogative, but they had to, through the interactive process, come up with some other reasonable accommodation, which could have been working part-time. It could have been working full-time closer to home.
Can I go back to just make sure I understand your position? Because you started by saying it wasn't a vacant position because people could not apply for it. And then in response to Judge Agee's question, you say it is a vacant position.
Sorry, I apologize.
Those are like diametrically opposed answers.
It's really just a semantic game here.
Yeah, but the semantic game we're playing is the statute, right? You can call that a semantic game if you like, but we apply the words of a statute.
Right.
And it's
And
not semantics to us, it's the words of the statute.
no, I'm saying the exact type, what you call the reasonable accommodation doesn't matter here. It's a job share, and it can be characterized as a job restructuring or part-time or modified work schedule. Or if you want to stick with the reassignment to a vacant position, you could see it as a reassignment to sharing half of Caitlin Hunt's job, which she agreed to do.
Counsel, this is Judge Rushing. Hi. Sorry, you
Hello.
can't see me. I'm on the phone.
That's okay.
I have a question about this, the idea that it could be job restructuring or a modified work schedule. My understanding is that she was a sales rep in Asheville. And now if she had wanted to job share that position, I might be able to see how maybe that's a modified work schedule, that's restructuring her current job. But if she wants to move to be a sales rep in Greenville, she's not doing her same job. No one's doing her job as a sales rep in Asheville anymore. I don't see how that could be restructuring or modifying the work schedule of her current job if she's moving to a different territory. Her current job is no longer being done, at least not by her. It's now vacant for someone else to do.
Correct, Your Honor. But she was performing the same essential functions. She was selling the same drugs. She just wasn't driving an hour and a half each way into the territory. And she had already
Well,
performed
it seems like the
that job
essential
in
function, I mean,
Greenville.
from Sanofi's perspective, the essential function is selling the drug in Asheville. They need someone to sell the drug there, and that's what they've asked her to do.
Well, they have not made that
selling the
argument, Your
drug-
Honor, that the essential function required being done in
All right.
Asheville.
Hold on a second. Counsel, hold on a second. I think Judge Rushing was still speaking, so
I
let's be
apologize.
careful when the judge is talking to wait until they're finished.
I apologize.
Judge
I guess,
Rushing?
counsel, thank you, Judge Agee. I was just trying to drill down on this perspective. I think only the EEOC raises this. The parties don't raise this, but to the extent you're talking about it being a matter of semantics, we can call it anything we want. I think the fact that no one else is doing her job in Asheville is a reason why we might not be able to call it restructuring or a modified work schedule, and we have to talk about a vacancy.
Okay, Your Honor. The company has not suggested that performing the ESP job in Asheville was the essential function of the job. And her own supervisor asked that she be able to do a job share. The company, HR, approved a job share for Greenville. So as long as she's splitting a current job in Greenville, the company isn't paying someone else to do her job, which is what is suggested by creating a new position. So, and I don't know, I hope I didn't mislead you by saying it's only a matter of semantics. My point was that reasonable accommodation is of the type that is listed in the statute is reasonable here on its face in the run of cases ordinarily because the company's flex policy allows for it and HR had approved the Greenville job for a job share. So the company, to the extent it had concerns about business problems, would be able to show that it created an undue hardship on the operation of its business. But the problem was resolving these factual disputes at the reasonableness stage, where the Supreme Court in Barnett has said that that inquiry is a general examination of whether the method requested is workable, is it feasible? And then the burden shifts to show that because of the way the company works or because of whatever their concerns are, that it would be an undue hardship. And that is how the duty to accommodate is written in the statute of the ADA. So the duty to accommodate takes what Judge Ruth Bader Ginsburg said, a starring role in the statute. And here that they have a policy of not granting job share for business reasons, that ordinarily wouldn't be enough to say that the accommodation sought was unreasonable. Instead, they would have to show that on undue hardship. So the problem is the burden, and I wanted to point out too, because the company never participated in the interactive process.
Counsel, you're somewhat over time,
sorry.
so
Okay,
how
I'll
about
stop.
bringing it to a close?
Thank you. Okay, I'll stop. Thank you very much.
All right, thank you. Ms. Sprain, we'll hear from you.
Good afternoon. May it please the court, I'm Teresa Sprain on behalf of Santa Fe. And it's our position that the district court's grant of summary judgment was proper on our motion for summary judgment. And this is because there can be no dispute that Santa Fe provided or offered a number of reasonable accommodations. The interactive process here was in fact robust. She was given 6 months of paid leave, a leave that was extended 3 times in response to notes from her doctor. And her physician confirmed that she could not perform the essential functions of her job in Asheville because she could not travel to North Carolina and she could not work on a full-time basis. She was given an offer to explore another position in Greenville with Debbie Anderson, the same supervisor that appellant says discriminated against her. She declined that position. She was offered or declined the opportunity to pursue that position. She declined hotel stays and said they would not be effective. She declined another car and said that would not be effective.
Ms. Sprain, hold up just a second. Judge Rushing, are you still there?
Yes, sir.
Okay, okay, your little box came on now. Okay, sorry, go right ahead, Ms. Sprain.
No problem. She had an ongoing opportunity to look for other positions in the company. When she could not return to her own position after the 6 months of leave and had indefinite restrictions, she was released to long-term disability. And Santa Fe sent her a letter at that time summarizing those accommodations. Ms. Perdue did not respond to that, to dispute it, to deny that that was so. She instead wrote a letter to one of her managers to thank Santa Fe for her opportunities and then filed her EEOC charge. And the argument she makes to this court today asks you to hold that in addition to the numerous accommodations that I have outlined, that the ADA required Santa Fe to modify the job of a non-disabled employee to accommodate a disabled employee based solely on their unilateral and private decision that they were willing to share the job. And this is not what the law requires. She wants the court to ignore established law.
Counsel,
yes.
Can you talk for just a second about Judge Rushing's question to the EEOC? They seem to, maybe not exactly, but they come awfully close to conceding that in the EEOC's view, there was no vacant position, but suggest instead that we should refer to this job sharing as restructuring or a modified work schedule. Tell us in your view why the change to Ms. Hunt's job is not restructuring or a modified work schedule that Santa Fe was required under the ADA to provide.
Because Ms. Hunt is not the disabled employee. Ms. Hunt is an employee who, while it is true, was also interested in applying for a job share. Santa Fe had a policy governing how job share operates.
Right, but I guess I take EEOC's argument to be that the ADA requires Santa Fe to change other people's jobs to the extent necessary to reasonably accommodate Ms. Perdue. Why don't help me understand why the ADA doesn't require Santa Fe to just change anybody's job in order to accommodate Ms. Perdue?
Right, because the other employees have rights in their positions as well, regardless of whether they want to yield those rights and say that I would be willing to share. The company still has to determine whether that is an appropriate sharing based on business needs, based on availability, based on the qualifications of principals. And so the fundamental question here is the position that is at issue to be modified is Caitlin Hunt's. There was no vacancy in Greenville for Janet Perdue. The only way that this could work, and which the company did explore and explored in detail, was to split Caitlin Hunt's job and allow Janet Perdue to take the other part of it. That in and of itself creates issues with accommodation of Janet Perdue, because employers do not need to create a new position. They do not need to assign someone who performs a full-time position to a permanent part-time position. There's no requirement of permanent light duty, and employers can follow their non-discriminatory policies. As I mentioned, there was an extensive interactive process, and that includes the discussion of this role. And
Counsel, if we determined, using the terminology of vacancy, that there was not ever a vacancy in this case, do the issues of pretext or interactive role come up, or does it end with that determination on no vacancy?
In our position, it ends because we are talking about restructuring. We're talking about all the issues I outlined that, as a matter of law, our courts have held that employers do not need to do as an accommodation.
So there were some items in the record, I don't know whether they were contested for purposes of summary judgment, that related to
Judge
a
Agee,
text. Yes.
Judge Richardson.
I don't have a box for Ms. Gantz anymore. Are you still there, Ms. Gantz?
Ms. Gantz is still there. She's turned off her video.
Okay. All right. Things in the record that may have been contested for summary judgment purposes, I don't remember right now, but one was to the effect that there had been a text message to Ms. Perdue about a position in Greenville, to which she never responded. And then there was an offer of hotel accommodations and a different car, I assume for ergonomic purposes, for her use in Asheville. So I'm assuming that those items would go to interactive process as opposed to any question related to vacancy.
I agree. Yes, Your Honor.
Do you agree, Ms. Sprain, that at least in the Fourth Circuit, the interactive process is not an independent claim? That if they fail to show a reasonable accommodation, there's not an independent process claim.
That's correct, Your Honor. I agree. And it is the plaintiff's or the employee's burden to identify that reasonable accommodation. And the only one that has been identified that Ms. Perdue says was not provided to her is this job share, which is the modification of Caitlin Hunt's position. There's not any other one that is outstanding. And it's our position that, as a matter of law, that Santa Fe was not required to do it. We have an extensive FlexWorks policy. I need to address the position that HR determined that Caitlin Hunt's position was eligible. Sales rep positions are eligible for job share, but it is the hiring manager's, Caitlin Hunt's manager's decision to make as to whether job share will be approved or not. And as it spells out in the policy, managers will approve or deny based on a number of business factors, including performance issues. I also want to address the issue that was raised that job share had been provided to Ms. Perdue in the past. And as we cited at page 24 of our brief, a prior accommodation does not mean that the same accommodation needs to be granted in the future. So while that may be true, I think that is evidence of Santa Fe working with Ms. Perdue when it was able and when it could accommodate her. But this accommodation in this circumstance was not reasonable as a matter of law.
Is my recollection correct, Miss Sprain, that she was offered a part-time position in Asheville?
There was discussion of that would not work for her.
But Sanofi suggested a part-time position in her current role, and she rejected that.
I believe that was discussed, but her restrictions would never have permitted her to do that because of the travel. So that wouldn't have been feasible for her.
Okay.
Your Honor asked a question about pretext, and I do not believe that the court needs to reach that issue, but we do want to make clear that if the court were to analyze this case under that framework rather than simply as a reasonable accommodation, that Ms. Perdue cannot prevail there either. She has not demonstrated evidence of discrimination. She has not demonstrated that there was pretext. She was evaluated in this process by a manager who sought to give her another job, and it just does not follow that that manager would seek to discriminate against her on the basis of this job. Your Honors, I have covered the points that I wanted to address for the court today. Unless you have questions for me, I'll conclude.
Judge Rushing, do you have anything further?
No, thank you.
Right.
Judge Richardson? All right, thank you, Ms. Sprain. Ms. Gessner, you've got time in the rebuttal, so we'll hear from you.
Yes, Your Honor. Thank you. On the vacancy issue discussed by the law requires the court to look at it really under two scenarios. Was the position vacant or likely to become vacant? Reasonably likely to become vacant. We mentioned that in our briefs. In this instance, from February of 17 until May of 17, everybody believed job share was going to be approved. That is undisputed. The record is rampant with evidence to show that HR approved it. Tim Cole approved job share. It was going to be approved. And in fact, Ms. Anderson, the decision maker here, wanted to interview the two applicants for the job share and conducted an extensive interview in April of 2017. An extensive interview in which that she pried very in depth, again, a question of fact. It's Ms. Perdue that she asked in depth about her disability, and shortly thereafter, the decision is made to deny the job share. So here, Your Honor, if you're troubled by the vacancy, the law requires to look at what did the employer do? The employer treated the position as likely to become vacant by walking through the process of considering the job share. If job share wasn't a reasonable request, Your Honors, why did they consider it? It's a circular argument. There is precedence, again, persuasive out of the District of Massachusetts that's cited in the briefs, the Cutto versus Newton Public Schools, that expressly says, if you've job shared before, then it can be deemed reasonable on its face and can only be denied absent with an undue hardship. At all turns of this case, the company had undue hardship in its quiver, an arrow in its quiver to shoot. It chose not to. Instead, it said, after interviewing Ms. Perdue in person and inquiring at length about her health condition, shortly thereafter denying, the denial was, quote, doesn't meet the business needs. There was never any explanation of undue hardship whatsoever. And Your Honors, our position is it was reasonable on its face for many reasons, and including a reassignment to this likely to become vacant position that they treated as such was also reasonable and could only be denied absent undue hardship. The company did not engage in the interactive process at all. In fact, their own dismissal letter says, we haven't spoken to you since May of 2017. Crab Bill, this court has recognized in Crab Bill, the party who drops the engaging in the interactive process can be deemed engaging in bad faith. Here, Ms. Perdue did in fact attempt to get a part-time job or inquire about it through the Reed Group. There is an email at JA 262 from Meredith Hernandez dated May of 2017, May 15th of 2017, where the manager says, this territory cannot accommodate a part-time position, period. It wasn't Ms. Purdue who in any way rejected part-time. Also, Your Honor, an accommodation must be effective in order for it to work. Here, Ms. Purdue's medical provider said a car or a hotel stay would not allow her to work within her restrictions for her health. It was 30 hours a week in a territory close to home. A new car was not effective. A hotel stay was not effective. And importantly, Your Honors, when HR mentioned this as a potential offer, HR testified they didn't even know it was to accommodate a disability and that it was to just be, quote, a good partner. There was never an offer made whatsoever that would be effective in allowing Ms. Purdue to return to work and have an equal opportunity to keep her job, which is the intention behind the ADA to begin with. Likewise, Your Honor, there was engaging in bad faith. Rather than engaging in the interactive process, Sanofi was digging into Ms. Purdue to determine whether or not her going to school somehow indicated she didn't have a disability and she could work in Asheville. Ms. Purdue, every 3 weeks, was having her certifications recertified, her medical providers telling Sanofi she could work and looking for other jobs, calling anyone who would listen, the Reed Group, HR, her former managers. There never was a single job opening. Sanofi would like this court to believe that Mrs. Purdue turned down a job. That did not happen. And to the extent there's evidence conflicting, it was a question that should have gone to the jury. Ms. Purdue testified there was a mention in January of 17 about the possibility of an opening back in Greenville. And importantly, Your Honor, she worked in Greenville for 16 years. She was involuntarily moved to have to commute from Greenville to Asheville, a 3-hour drive one-way back roads. Sanofi admits it wasn't the driving, it wasn't the, quote, windshield time, it was her disability, her hands going numb, her feet going numb, that was precluding her from driving. When that, may I continue, Judge Agee?
Yes, go right ahead and finish your answer.
When that supposed conversation happened in January of 17, Ms. Purdue was asymptomatic. She had returned to 100% capacity. The record is clear. She worked in 2016 at 80% capacity. In September of 16, was back at 100%. When this conversation occurred, Purdue was happy to have a job. She was happy to tackle and try Asheville. It only took about 45 days into the market before her doctor said, you're going to end up back in a wheelchair. And her manager, Meredith Hernandez, agreed and in fact advocated in writing that a job share be considered as a reasonable accommodation. And Your Honor, if reasonable is met in the request, the only way Sanofi gets to deny it is undue hardship. And that is the element where Mrs. Purdue met it here. And it certainly should have gone to the jury to decide to the extent there was an undue hardship and to the extent there are questions of fact as to the reason it being denied. I mean, again, Sanofi did nothing from May of 2017 until September of 2017 to engage in the interactive process with a single offer. Unlike in Elledge, where Lowe's seemed to have bent over backwards to try to accommodate, had in writing potential accommodations that would work in conjunction with contacting his medical providers, Sanofi did none of that here. They were indifferent to the ADA. They didn't contact her medical providers at all to find out what would be effective. They offered nothing. They put her out to pasture, called short-term disability, and she didn't want to be there. She tried every 3 weeks to get back to work. And Your Honors, the records reflect that they said, go get on long-term disability and wrote her off. She wasn't ever approved for long-term disability. She was 45 years old when diagnosed and 50 when she was fired. This was someone who fought for her job to the very end, and Sanofi didn't care. And they violated the law because they absolutely didn't make any efforts to engage, find another accommodation, and absolutely could only deny the reasonable request under the ADA if they could demonstrate undue hardship. And all of this should have gone to the jury. It could go to the jury. If they can demonstrate undue hardship, Your Honors, they can do it before a jury. This case should not have been granted summary judgment because the facts were all construed in the light most favorable to Sanofi, not Janet Purdue.
All right, thank you very much, Ms. Gester, and I want to thank all the counsel for their briefs and their argument. As you know, if you've been to the Fourth Circuit before, when we're not on video, we come down and shake your hand, which obviously we can't do today, so we'll hope that in the very near future you'll be able to come back and we can do that. So I'll get the clerk staff to now move us to our next case.
Thank you, Your Honors.
Thank you.
Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
So I can see Judge Richardson, but I can't see the lawyers. There they are.
Okay, you can see them, Judge Agee?
Yes, ma'am.
Great.
So we're ready to hear argument in our next case, Old Republic National Title versus Schulman Rogers et al. Mr. Marinello, you're up first.
Yes, Your Honor. Thank you. Good afternoon, and may it please the court. The district court's entry of summary judgment in this case and in favor of appellees Morton Fowler and the law firm of Schulman Rogers should be reversed because the district court erroneously determined that the appellee's malpractice caused no harm to Old Republic. That conclusion was incorrect for two primary reasons. First, in determining that Old Republic still would not have prevailed on its claim of equitable subrogation absent appellee's malpractice, the district court misinterpreted and misapplied Maryland law on equitable subrogation, unnecessarily limiting that broad doctrine and overlooking its primary purposes of avoiding unjust enrichment and honoring a refinancing lender's intent. And second, in determining that Old Republic also would not have prevailed on its equitable mortgage and reformation claims, the district court conflated the concepts of mutual mistake and intent, and it disregarded overwhelming evidence in the record demonstrating the party's intent to create and enter a refinance mortgage secured by the property. Had the district court properly applied Maryland law and properly assessed the record, it would have and should have determined that but for appellee's malpractice, Old Republic would have prevailed on these claims in the state trial and appellate courts.
Counsel, if I could interject, as I looked over this case, I was struck with the thought that, obviously we have no federal question here. These are all, you might say, somewhat esoteric questions of Maryland law. And we have multiple decisions from multiple courts in Maryland, including cases from the Maryland Court of Special Appeals that seem to be relevant that postdate the district court's opinion here. And it occurred to me, which you might want to respond to, and opposing counsel as well, is that this might be a viable candidate for certification to the Maryland Court of Appeals. I mean, basically, we are trying to guess as to what the Maryland Court of Appeals would do in the circumstance where they had heard the case if there had been a timely appeal filed. And I just wondered whether it might make more sense to let them actually tell us.
Your Honor, I think the question is certainly hits the nail on the head in terms of what the substantive issue is, which is what would have happened on appeal in this case had the appellees timely noted that appeal. Now, that being said, I would note that the issue is still ripe insofar as the appellee's malpractice involves standing in the trial court. The failure by the appellees to establish standing on behalf of First Horizon at the time led the state trial court to adjudicate the case on that issue. And while the state court did at least purport to decide the case on its merits, we believe that decision was still very specifically limited to reformation and mutual mistake, and that it did decide the case, decide the claims of equitable subrogation on standing alone, and didn't decide equitable mortgage at all. So there is some concern on Old Republic's part that even if the case was timely noted for appeal and did proceed to an appeal, one could foresee the Court of Special Appeals solely deciding the case on standing and saying the trial court had the case right on standing. We see no need to address these issues substantively. But I take Your Honor's question to heart, because this is a matter of what would the Court of Special Appeals had done. I don't know that it's a certification that would be limited to a specific question, because really that certification would involve the Court of Special Appeals essentially reviewing the record and conducting the appeal as it should have had the appellees not committed malpractice. So I understand Your Honor's question, and hopefully I've given an answer that is responsive to it. That being said, the $1.1 million refinancing mortgage loan at issue in this case.
All right, can I I'm trying to process that. So do you have any objection, I guess is another way of asking Judge Agee's question, to us, and you may not be familiar with our process of certifying questions to the state courts, but we're entitled to certify specific questions. We don't have to send the whole appeal over. To certifying the questions with respect to equitable subrogation and mortgage, and how those were treated to the Maryland courts. Do you have any objection to us doing that?
I can't say that I would have an objection to you doing that. No, Your Honor, to this court doing that. I wonder a little bit. It seems to be a difficult question to frame and to pose for the court, only because I think it's necessary to look at the facts of the case in order for the court to understand. If the question was, for example, does equitable subrogation apply in an instance like this, where a deed is defective because of the two tenants by the entireties holding the property, only one signed that deed? I think a question like that could be framed specific for the Court of Special Appeals. That being said, I think there is existing law, as we've cited in the brief, on that particular issue. For example, the Bank of New York Mellon versus Ashley case out of the district court in Maryland, which does address that issue. And we do see equitable subrogation being applied to that circumstance, which is the circumstance here in this case. So I do believe there is law that could be used to decide the issue. But to answer your question, Judge Richardson, no, that we would have no objection to doing that.
Well, with respect to that part, and I don't want to take but so much time of your argument on the merits. The Ashley case was a district court opinion. It wasn't an opinion from the Court of Appeals of Maryland. And as your briefs of both sides indicate, there are cases that say somewhat different things depending upon their history about the topic of equitable subrogation, for instance. So one wonders whether that the most recent case, the 2020 case, JP Morgan Chase Bank, is a more accurate representation of cases that were given earlier. But the in our certification process, we only certify the question if the answer to be given would resolve the issue before us. So if the issue before us is, for instance, had the notice of appeal been filed on time and the court dealt with the question of equitable subrogation, if it determined that indeed equitable subrogation would have been available, then that would seem to answer the question of proximate cause, and vice versa. And that was my intent in bringing the topic up.
And I appreciate that, Judge Agee, and I think that is a viable question, and I think it is essentially the answer we're trying to obtain in this case. So again, we would not have an objection to that. I am glad, Judge Agee, that you brought up the JP Morgan Chase case from 2020. I was not going to specifically raise or attempt to rely on it, of course, because it's unpublished, but we do believe that the court's analysis in that case is pertinent, and even to the extent that there was a motion potentially pending whether to publish that case, the court could also weigh in and that case, its analysis of the cases we have cited here, the Court of Special Appeals takes some of the cases we've cited here and analyzes them. And it does it in a way that I believe is consistent with the argument we're making here. So again, I do think that is a viable option, and it's one that Old Republic would not object to, Your Honor. With respect to that first issue that I raised, and before I do that, I did want to just sort of point out that the $1.1 million refinancing loan that was extended by First Horizon in this case to Mr. and Mrs. Georg was at their request used to pay and satisfy their two pre-existing Chevy Chase mortgages in the amount of $917,000. From the loan documents in the record, that loan was also clearly intended to be secured by the property and was intended to give First Horizon a priority position that was previously held by Chevy Chase Bank. There were no other liens or encumbrances at issue in this case. While Mr. Georg was the sole borrower on the transaction, the deed of trust did need to be signed by both he and his wife because they held the property as tenants in the entireties. The only issue in this case, the only issue in the transaction was that the deed of trust securing the refinance loan failed by mistake to include Mrs. Georg, and it only included Mr. Georg. Of course, when First Horizon was then in a position to try to foreclose on the property, it was unable to. Old Republic, as the insurer for First Horizon, engaged its longtime counsel, the appellees, to pursue and obtain what even the appellees, as demonstrated in the record, believed and advised Old Republic was almost certain relief in the form of equitable subrogation or reformation or equitable mortgage. And it's due to the appellee's malpractice that did not happen. Instead, judgment was entered in favor of the Georgs, granting them a $917,000 windfall. The reason I give that background is because the district court summarized Maryland law on equitable subrogation in the following way. It stated, quote, Maryland courts have interpreted equitable subrogation in the mortgage context to be appropriate where an intervening lien holder, of which a refinancing lender was excusably unaware, jumps the queue in terms of loan priority status. And the court went on to conclude and to hold on the equitable subrogation issue that, quote, because First Horizon's loss of its priority status was not a matter of line jumping, but of defects in the transaction itself, the court concludes that equitable subrogation does not provide a basis to grant relief to First Horizon. That's a fundamentally inaccurate statement of Maryland law on equitable subrogation, and I would submit even equitable subrogation in other jurisdictions, because unnecessarily limits equitable subrogation to cases involving this quote unquote line jumping. And it also implies, if not directly states, that equitable subrogation can't apply to cases involving defects in the transaction. Those two issues, I do think, are crystal clear from the Maryland law that we do have. As briefed by Old Republic, there's a multitude of cases where equitable subrogation is implied without any line jumping that's involved. And those same cases also involve defects in the transaction. They include, for example, from our brief, Bierman v. Hunter, Fishman v. Murphy, Milholland v. Tiffany. Those are the state cases, and there are federal cases, Bank of Holiday v. Holiday, which this court affirmed, and Bank of New York v. Ashley, which is the Ashley case we mentioned a moment ago. Those cases make crystal clear, and a couple of them, even when you take Milholland, which is the first case where equitable subrogation was applied in the mortgage context back in 1886, the court actually noted how there were no intervening liens in that case, and it explained how equitable subrogation is appropriate so long as there are not existing intervening liens. So from the inception of equitable subrogation being applied, we know that it applies where intervening liens are not at issue. And again, those cases also involve defects in the transaction. The Milholland case described it as a defective mortgage because there was a procedural defect in the oath. So there is ample case law, Your Honor, that demonstrates that the district court's approach to Maryland law on equitable subrogation was clearly erroneous. And by taking that different view in the district court, it almost couldn't avoid making an incorrect decision. It unnecessarily limited how equitable subrogation is applied, and it determined that Old Republic would not have prevailed if there hadn't been malpractice and if it had its day in the state court, or trial court, and the appellate court. Contrary to the district court's interpretation of the law, Maryland law, with or without certification of the Court of Special Appeals, is quite clear, we believe, from the cases cited, that it enjoys broad application to deeds of trust and mortgages, and it focuses on avoiding unjust enrichment, preventing harm to other lien holders, and honoring a refinancing lender's intent. Again, we see that in the multitude of cases that we've briefed. By example, the Egili case from the Court of Special Appeals tells us that the primary purpose of subrogation is to prevent unjust enrichment. The Fishman case by the Court of Appeals indicates that, again, while noting equitable subrogation enjoys broad application to deeds of trust, it stated the purpose of equitable subrogation is to prevent inequitable consequences.
If you fail to prevail here, what do you describe as the unjust enrichment?
The unjust enrichment that we see, Your Honor, is that the Georgs were given a $917,000 windfall by First Horizon satisfying their Chevy Chase loans. So they did not have to satisfy those. A separate lender satisfied those. And they then took their property free and clear of the $1.1 million loan that they requested from First Horizon on their property. So that it's difficult to imagine sort of a greater windfall where they've had their $917,000 pre-existing mortgage loan satisfied and are able to walk without any security lien on their property and don't have to essentially pay that loan to free their property. So we believe that is
you still have an unsecured claim against Mr. Georg.
It remains unsecured, correct, Your Honor, unless and until the property were to be split, if they did not hold the property as tenants by the entireties. But you're right that there is an unsecured loan there. But we would submit that is why equitable subrogation exists, when the intent is clear for the parties to for a payer to come along and to satisfy a pre-existing mortgage loan, which enjoys priority status. The payer is not a volunteer. The payer is not obligated to pay that loan. It pays the loan and it takes actions to protect its interests, and it pays the loan in full. Those are all the classic elements of equitable subrogation that allow that payer to step into the shoes of the prior lien holder. So while there may be an unsecured interest, an unsecured loan that First Horizon held and now Old Republic holds as the subrogee. Equitable subrogation exists to correct that. It does no harm to the Georgs. It leaves everybody in the same place as if the refinance loan never occurred. And I see that I'm up for time. My time is up, and I'll reserve. I'll wait for my reservation. Thank you.
All right. Thank you, Mr. Marinello. Mr. Frederick, we'll hear from you.
May it please the court, in response to the question posed, Judge Agee, by you and also in part by Judge Richardson, I would submit to the court that if in fact the findings of the original trial court, in this case, Judge Alexander in the Circuit Court for Baltimore County, are given deference and are not by this court found to be clearly erroneous, on this record, with the finding that Mrs. Georg did not intend to be a party to this deed of trust, did not intend to give any security, I would submit to the court that on the state of the law as is presently there for the court to consider, and that does not include an unreported decision of Maryland's Intermediate Appellate Court, which by rule I can't even cite to unless it's in a case that it's related to, i.e. the same parties or parties in privity, nor can it be cited by rule. So that case, for all intents and purposes, doesn't count. So under the state of the law,
is Mrs. Georg's intent relevant to the equitable subrogation case as opposed to equitable mortgage?
it is indeed, Your Honor, because if this is, as Judge Chuang noted in his opinion, trying to convert an unsecured obligation into a secured obligation, whether she intended to be bound or not is relevant. And it's important to note that based on the record, there's $907,000 of obligation that's sitting there at Chevy Chase Bank. It's the original construction loan and the home equity loan. But this is a loan for $1.139,116,000. It's perfectly rational that Mrs. Georg didn't want to subject herself to that kind of additional exposure at this transaction. Interestingly, the closing instructions from Old Republic to the closing agent, its agent by admission, said best title in Mr. Georg. They prepared the deed of trust and the note. Her name doesn't appear on either one. And as Judge Richardson points out, they got what they bargained for. They got a note from Mr. Georg. They can prosecute as to Mr. Georg. They have other remedies as well, their own agent.
Oh, but they didn't get what they bargained for. I understand you're an advocate, but not even you can, suspect actually say that, because they got a mortgage that, because of the tenancy of the entirety, was wholly worthless, right? We all recognize that they signed a piece of paper that could have no value. Now, I understand your other arguments, but when you say they got what they bargained for, that takes it a step far, I believe.
Fair enough, Judge, fair enough. I accept that. What I meant by that comment, and probably poorly worded on my part, is they prepared the deed of trust. They sent over the information saying vest in him only. Their agent knows the true state of the title because he does the title work. And notwithstanding that, he only has Mr. Georg sign the deed of trust. And then he certifies the title with both of them. They're in the position of dominant bargaining. And all the cases cited are talking about kind of mistakes or defects in the title. What we've got here is we've got a screwed up title to start with. They don't actually get anything right, and they're the ones who fumble the ball right off the first play. It's not, there's a fraud.
Are there any cases that you could suggest that stand for that idea? That though other, and this is obviously not what the district court found, but though otherwise equitable subrogation would be appropriate, it is not because the mistake was made by the party with a dominant, bargaining position.
I can't really think of one, Judge, but I would respectfully suggest that the real remedy here, if you look at the complaint that's filed, and another law firm filed essentially the same claim in the second case and didn't change it, it's to reform the original transaction, because the appellant says, oh, everybody intended it was going to be both of them. Essentially what you and I were just talking about with whether they got what they bargained for. And if in fact that's true, the remedy isn't equitable subrogation. The remedy is either the reformation or equitable mortgage, which of course they tried to get. The problem with equitable mortgage is, from the appellant's perspective, that requires mutual intent. And here, the trial court, who had the ability to observe the witnesses and made the finding of fact that Mrs. Georg didn't intend, even with the exchange with counsel. It's at JA 196 to 200.
So I get that with the equitable mortgage, but it doesn't seem to apply to equitable subrogation claim. I mean, that's I think Judge Agee's question from a minute ago sort of goes back to why does her intent, I get your point on equitable mortgage, but why on equitable subrogation, that doesn't seem to show up in those cases. And I'll agree they're not always a model of clarity.
Well, there's an interesting case out of Missouri that's cited in one of these cases. It says equitable subrogation really depends on the facts of each case. And obviously, equitable subrogation requires equity. One who seeks equity must do equity. And if you convert this over the way the appellant says in their reply brief, you're really turning this into a no-fault doctrine. You know, just the lender says, the lender says. Every one of these cases, the lender...
No, you don't. But that's you know, I mean, you got a position, but I don't want you to overstate it, because we sort of just posit that most people would think that they didn't get what they bargained for, right? I mean, this is back to our earlier point that regardless of the intent of the parties, it'd be difficult to imagine that they signed this mortgage knowing that it was worthless and could not have given a tenancy entirety any value.
Well, it's not necessarily...
I understand your point about her, but that seems like exactly what equitable subrogation is about.
Well, the mortgage, just as an aside, isn't necessarily worthless. It's been noted that it is potentially, depending on what happens with her and their status as tenants by the entireties, there's potentially value in the deed of trust. But they're the ones that prepared it the way it ends up getting signed, notwithstanding only Mr. Georg applied for this loan. And there's no evidence that anyone on the appellant side ever told Mr. and Mrs. Georg what their intent was, what they really intended, as you and I have been discussing, which is to get this security. There's no evidence of that was presented to the trial court, which again goes back to...
I don't think opposing counsel will argue with you that there are mistakes made, and whether or not the ones who made the mistakes still have a job or not, the record doesn't reflect, and that really isn't relevant for here. But in looking through this, there were several cases. I think Westfall was one of them, where the party who wanted equitable subrogation had not been prudent, had been negligent. They had either recorded in the wrong place, they had not done a title examination when they offered the substitute loan. So there was negligence in those cases, but I think there was still equitable subrogation found. So I'm not, unless you've got some pretty definitive law, I'm not sure the fact that Old Republic or First Horizon was negligent is dispositive.
But Judge Agee, in none of those cases was there an issue as to whether or not there was either an intention or a willingness on the part of the debtor to be subrogated. Where there have been these, there's a case that's cited, and the name is skipping me for the moment, but it's a bankruptcy case, and it's the U.S. has tax liens and is trying to get an intervening lien. And in that case, the borrowers consented to having equitable subrogation. And that's pretty much the situation in a variety of these cases. There's not one that I've seen where there's a question as to whether or not one or both of the borrowers intended to be bound. There are cases where there's fraud on the lender, and the argument there is, well, that's not the lender's fault, and therefore they should be equitably subrogated. They should be able to jump in line. But the issue here is, irrefutably, unless this court concludes it's clearly erroneous, there's a finding that one of the borrowers did not intend to be part of this transaction. And under that set of circumstances.
That's true of the forgery cases too, right? I mean, the fact that when, you know, the cases we've got, and I'm not a names of cases guy either, but where the husband forges the wife's name, it'd be undisputed that the wife didn't intend to be bound by it any more or less than this woman did not intend to be bound by it.
Totally agree, Your Honor. But in those cases, the spouse didn't have an objection to being equitably subrogated to some of the debt, not all of the debt, but some of the debt. And that's what the court ultimately did. There's a divorce case in particular that's coming to mind where there's the husband's in Brazil, can't remember the darn name of the case, but the hubby goes to Brazil and he leaves her kind of holding the bag. And there's a couple of loans that he takes out in between. And she doesn't have any problem with, oh yeah, the original loan that we were both on, you all should be subrogated to that. And that's what the doctrine is for, which I think is a fair reading of the cases. I think that's the way Judge Chumong read the case. The doctrine is not here to take something that is unsecured as to Mrs. Gearworth, and arguably unsecured, as you and I have been discussing, as to the parameters of it, as to the lender on the joint tenants, and convert it to a secured transaction when all of these facts are presented to the trial court. Everything here was before Judge Alexander, and he makes the findings of fact that he does based on the fact that he has the witnesses before him. And under that set of circumstances, isn't it really equitable mortgage, not equitable subrogation? And under equitable mortgage, they fail because they can't get it reformed. It's the same doctrine, same analysis as under a reformation kind of situation. Which is why I suggest to this court that Judge Chumong in his analysis of this was correct, and this case ought to be affirmed. And it's also why I respectfully don't think that it's really a case for certification to the Court of Appeals. And you know, the argument is, well, what would the Court of Special Appeals have done had this case been properly appealed, had it been before it on the original record? I think this court can easily substitute itself for, and it really doesn't matter whether it's Court of Special Appeals or the Court of Appeals, because there could have been a certiorari. In Maryland, you can jump cert over the intermediate appellate court if the appellate court agrees, and if you don't get it the first time, you get cert the second time if the appellate court agrees. So it's really this court putting itself in the same position that the reviewing court would have been in right after the trial, looking at not a dispositional motion, but a disposition before trial court with regard to findings of fact that wipe out mutual mistake. And I respectfully suggest, given the whole plethora of mistakes that are made, awfully hard to figure out what intent is where. But by way of example, the appellant tells you that, well, there's a couple of documents signed that suggest that the borrower is Mr. and Mrs. There's also a plethora of documents that are signed that tell you that the borrower is Mr. And we have the closing instructions, we have the loan application. All that's before the fact finder. The fact finder makes his conclusion. This review on appeal, whether it's here, whether it should have been in front of the Court of Special Appeals at the time, would have been on the record as it was presented from the trial court and the findings of Judge Alexander. His conclusions of law reviewed de novo, but his findings of fact reviewed with a clearly erroneous standard with due regard given for what he found and the way he found it. And unless there are any other questions, for all of those reasons, I'd respectfully ask that this court affirm the district court and grant summary judgment.
Judge Rushing, do you have any questions?
I will ask one question, if I may. We haven't mentioned really the Court of Appeals decision in the Boney Mellon versus Georg case, counsel. And as was discussed in the brief, the Court of Appeals there said that Ms. Georg's intent was, had already been litigated and decided, and that was dispositive for the claims in that case. And the claims in that case included equitable subrogation, equitable mortgage, reformation, et cetera. I'm left wondering what, if anything, should I do with that? It was in the context of deciding collateral estoppel. So there's not a lot of discussion of it, but they do seem to be saying that her intent is the relevant question for all of these issues. Although, as we've been discussing, we may have doubts about that, but this is the Maryland Court of Appeals. What do you suggest we must do or can do with this decision?
Well, Your Honor, I think the point of the Court of Appeals decision in Bank of New York Mellon versus Georg is that it confirms that the proceedings before Judge Alexander were on the merits. There's a contention that he only dismissed versus on standing, which would mean that there was never a merits determination and there was never a finding. And
right. I agree with you about that. That's what they were talking about. But to find collateral estoppel, they had to find that the issue, the same issue, had already been decided, and that issue was dispositive of the claims in front of them. And that's what they say at the very end of the opinion. And the claims in front of them were claims for equitable subrogation and equitable mortgage and reformation. So it's not exactly the same question. I agree with you, but I'm wondering if there's some level of deference we need to give, or if this is some sort of indication or forecast of what the Maryland Court of Appeals would say in this case.
Well, Your Honor, I think it does give deference, and it does treat the findings of fact by the trial court, Judge Alexander, in the Circuit Court for Baltimore County appropriately, and it means that this court ought not to disturb those findings as they were not clearly erroneous. I think that's the conclusion to be drawn, because the Court of Appeals essentially adopted Judge Glass's opinion from.
Yeah, well, I mean, the Court of Appeals obviously wasn't reviewing that decision. They weren't asked whether those were clearly erroneous. They were just asked whether they were decided. I guess my point is just that they found not only was the issue decided, but they said that the question of her intent is what's relevant for deciding these legal questions, which I thought is what we had been talking about earlier.
Yes, ma'am, I would agree with that.
That's all I have. Thank you, Judge Agee.
Judge Richardson? All right, thank you very much, Mr. Frederick. Mr. Marinello, you have some time in rebuttal.
Thank you, Your Honor. Addressing just a couple issues in reverse order, I'd like to just touch on the Court of Appeals decision that was just raised by Judge Rushing. And I would point out, I'm not quite sure what specific portion of the opinion Judge Rushing was referring to, but we did point out in our reply brief that a portion of that opinion appears to have been sort of mischaracterized or misquoted by the appellees in their brief. And so I do want to just call the court's attention and invite sort of carefully paying attention to, because one portion.
Yeah, I agree with that. There's, I think page 737 or something, they're quoting the lower court, but the last page of the opinion, 757, it's not as cut and dry as, or as explicit as what the lower court said, but, the Court of Appeals says on 757 that whether Susan had the requisite knowledge and intent with respect to the execution of the refinance deed of trust is dispositive of the claims in that case, which included equitable subrogation and mortgage and reformation.
I see that, Your Honor, and I think what the follow-up point I was going to make on this issue is that the Court of the Court of Appeals decision really focuses on whether whether these claims and issues reached final judgment in the initial case, in the state court case. And it is true that they did reach final judgment, but as we I think put in our reply brief, the state court here did not necessarily, the Court of Appeals did not assess whether the state court correctly resolved those issues. I do think it's the findings of fact that we're talking about that were made by the state trial court here are severely limited. They are limited solely to mutual mistake with respect to her signing the deed of trust. And as we pointed out in the reply brief, that is a different question than the intent to enter into a mortgage loan. The deed of trust was but one document. And while counsel for appellees has appointed to a couple of documents indicated and is arguing the negligence or the fault on the part of First Horizon, there are also clearly documents like the title commitment and others that reference a deed of trust to be signed by both Mr. Georg and Mrs. Georg, and that the fact of the matter is that it was simply a mistake that did not happen. And I believe it's I think Judge Agee correctly pointed to the Bennett v. Westfall case where that type of negligence, and the court gives a very telling statement in that case that type of negligence is not intended to benefit the Georgs in this situation. I would submit lastly, and I see that I'm about to run out of time, if I could have just a few more seconds to make this final statement, Your Honor.
Yeah, go ahead and sum up.
To the extent that the appellees assert that reformation or equitable mortgage are the proper remedy, there's an interesting colloquy in the record. I think you can find that it's attached to the affidavit of Mr. Baker beginning at JA 678, and there's emails there where Morton Fowler actually sort of advised and recommended to First Horizon not to file summary judgment on equitable subrogation because it seemed so clearly applicable, and if it was entered, he wasn't comfortable going to trial and asking for additional or more relief in the form of equitable mortgage and reformation. And the reason that this sort of debate exists between these claims is equitable subrogation is a lesser relief for First Horizon. It is only going to get what Chevy Chase had in the first place. By not sort of abandoning or not going for the equitable mortgage claim, which would entitle them to a $1.1 million judgment, the reason equitable subrogation exists is because it doesn't harm the Georgs. It puts everybody where they were had this refinance mortgage not taken place.
Well, thank you very much. I appreciate the arguments from both counsel. As you're probably aware from prior practice, it's our practice at the end of oral argument to come down and greet counsel. Obviously, that's not possible by video. So I hope that both of you will be able to come back at a later time post-COVID when we can come down and greet you in person. So with that, I hope you all have a safe weekend and stay safe health-wise. And with that, I will then ask our clerk to adjourn court for the day.
Thank you, Your Honor.
This honorable court stands adjourned sine die. God save the United States and this honorable court.